Welcome to the AIIC AI Chat, where conference interpreters explore all things AI.
Colleagues, the EU AI Act now governs a market of 24 countries and 450 million people. Today, we'll explore to what extent and in what ways it affects the provision of professional interpretation services. My name is Irina Paramonova. I coordinate the AIIC Science Hub and convene the AI workstream. And I'm also an English-Russian conference interpreter. I'm joined by Pavol Šveda, Professor of Interpreting at Comenius University in Bratislava and a member of the AIIC AI workstream, and Laura Holcomb, online events producer, conference interpreter, and member of AIIC's technical workstream. You don't see her, however, Laura is the one behind the fabulous sound of this podcast. Our guest today is Professor Yaniv Benhamou, Director of the Digital Law Center at the University of Geneva, Professor of Digital Copyright and Information Law, Attorney at Law, and a member of the Swiss Broadcasting Complaint Authority. His research focuses on new technologies, including AI and big data, creative industries, and the regulation of platforms and social media. In his book, Creative Value Chains, Copyright and Beyond, for a better value distribution, Professor Benhamou examines how digital platforms increasingly capture the value generated by creative and digital labor. My thanks as well to colleagues from the AB AI Ethics Group, Stefana Marone, AIIC Italy, Annie Benedictus, AIIC Netherlands, and Christian Driesen for their contributions, and of course to the AI workstream and the technical workstream, especially Magda and Danielle. And with that, I will hand the floor to Yaniv to open our conversation with the basic introduction. Yaniv, the floor is yours.
Thank you very much, Irina. Thank you to AIIC for the invitation. Just to follow up on the book mentioned by Irina, I indeed examined very carefully the change in creative professions from the creative industries such as music, video game, and visual art, and to see how platforms capture all the value generated by human creativity without sharing it. You can think of sharing platforms like TikTok that transform all interactions with internet users into money, that are monetized from user data to sharing to videos or photos posted by internet users. Think of AI models like ChatGPT, which extract from artistic works from the internet to train AI model, all without authorization or remuneration. Remember the Studio Ghibli from Miyazaki that has been harvested by models and allowed users of ChatGPT to generate millions of replication of Ghibli-style photos. So my book analyzed the transfer of value from users or artists to platforms, which poses a threat to human creativity and cultural diversity. And in the book, I try to suggest better ways of sharing the value, this value captured by platforms in three sectors: music, video games, and visual art. And in terms of solutions, I suggest contractualizing the value chain of the creative professions. Which brings us to today's podcast, because AIIC members are working as part of the so-called intellectual professions, and AI, in addition to the creative profession, changes also intellectual professions, which are meant to be driven by soft skills, driven by creativity, like artists and writers, or interpreters for interpreting texts and people, academia, as I'm also part of the academia and science, which helps to identify patterns in research, financial to predict investment decisions, and of course, legal professions, of which I'm part of, to review documents, draft contracts, predict cases. And as mentioned again, interpreters, because you provide real-time translation. And we know that many AI-powered tools from Kai to AST models, they convert and they change the professions. So in this respect, AI changes intellect professions. Some would speak about assistance as a actuarial tool that enables interpreters and professionals to focus on their main added value. Others will speak about replacement because some tools may be a threat of replacement, and others would speak about used because AI models harvest, extract many values found on the internet, also interpreters once, because they found some texts, some interpretation, some translations to feed and train their models into new AI models to generate new works. So in this constellation, again, be it for assistance helping interpreters, replacement, or being used by AI models, we all are aware that AI changes intellectual professions. That said, I'm myself pretty confident that due to the technical limits of AI models, they have not only benefits, but they also have technical limits. And particularly in interpretation services, we know that AI allows real-time translation, but translates verbatim and struggles with accents, humor, and non-verbal language, while interpreters interpret, understand the underlying messages, the cultural specificities, tone, and even humor. So I think AI is really limited by technicalities, limited to the training data, for instance, limited to the training languages with high volumes of available training data, but not for other minor languages or dialects with lower training data. And I think as a keyword, I'm pretty confident that there will be no pure replacement, but probably coexistence or even collaboration between machines and human beings. So if we need to stick to the three categories of AI being an assistant tool that replace or a tool that use, I'm confident, or let's hope, that AI will be rather a tool to assist and help, be it interpreters or any other intellectual professions. Having said that, let us mention few legal challenges in addition of the technical limits. There are many legal challenges for AI models. One of them is misinformation, deepfakes, manipulated audiovisuals, which is the world's biggest short-term problem to the global economy, which will threaten democracy. Last year, we remember that half of the population, half of the planet had elections. So misinformation is a major threat, major problem, particularly with deepfakes. A second legal challenge would be ethics and bias, because AI models reproduce stereotypes and inequalities because they reproduce bias in the training data, for instance, about gender, race, sexual orientation, or for interpretation services, lack of data for minor languages, dialects, or accents. And we speak about garbage in, garbage out. So if you have bad quality data in, garbage in, you'll have only bad output, garbage out. Third and last legal challenge to be mentioned now is, of course, confidentiality, IP, intellectual property, and privacy. Why so? Because AI models generate new texts, images, audio texts. They are all using training data sets, and some of them, or most of them, are protected by copyright, copyrighted data, texts, images, videos, or data protection and privacy. Think of Grok, of the X platform, or Meta AI, that train their models based on social media data or ChatGPT that used the New York Times News and many other copyrighted texts and works. So these two types of training data, from privacy to copyrighted works, from IP to privacy, led to copyright and privacy lawsuits. On the one hand, we have AI developers claiming that the data are freely available and they shall be able to develop their models to be trained, while content creators, creative workers, they claim that this is a theft of their data, mostly found on the internet. And there are leading cases. One of them is the New York Times against OpenAI. New York Times claims that OpenAI and Microsoft shall stop using training data found on the internet, particularly the New York Times texts, while OpenAI claims that this is impossible without harvesting the web to train powerful AI models without copying copyrighted materials. So we have now many ongoing lawsuits, and we'll see as an outcome what the judges will say about reusing training data. But just to finish on that, as an outcome, we have content creators, artists, writers, probably interpreters in the future, which will start to block all web crawlers, block their database previously found on the web. From Amazon to New York Times and even CNN, they now try to block web crawlers to reuse their data as training data, and which will rise in litigation and copyright lawsuits. So we enter, in my view, an era of the end of freely given training data, where AI models will start to pay for the training data sets. We enter potentially into an era of licensing market and potentially a reallocation of the value among different stakeholders. On the one hand, among creative workers, and why not interpreters, and on the other hand, the producers and all the stakeholders in the value chain. Having said that, I think it would be interesting now to dig into the detail with the AI legal framework, be it the EU AI Act or any other jurisdictions.
Yes, exactly. And I'd like to follow up on that. As Irina said, the EU AI Act is in many ways a pioneering legal document that regulates the biggest market, 450 million people, 27 states in the European Union, and quite clearly it has also implications to third countries. It is in many ways a pioneering legal framework because it sets the stage for regulating AI services or providers of AI services. So if you could perhaps navigate us through a specific part, or how could we as interpreters see the implications of EU AI Act on the services that we offer and also on the services that pretend to offer what we do, namely, for example, automated speech translation, or commonly and incorrectly known as AI interpreting. So in what ways and how does EU AI Act influence the work of interpreters and those who pretend to do similar work?
Sure. So first, let me just remind us what is the EU AI Act. So as you mentioned, EU wants to be a global leader in trustworthy AI and advocates to give the best conditions for innovation, but also advanced AI respectful systems while protecting human rights, trust. So they really want to be a global leader in that trustworthy AI. And therefore, they adopted a few years ago so-called EU AI Act, which is a kind of safety regulation based on a so-called risk-based approach. It's a regulation, so it's not a directive. Regulation under the EU law is a fully uniform piece of legislation that tries to exhaust and legislate the whole matter without leaving much rooms for member states, as opposed to directive, which needs national transpositions. It has a very general scope, but we always need to remember that it's part of a wider legislative ecosystem, because on the top of the EU AI Act, there are many other pieces of legislation, digital regulations from the GDPR for privacy and data protection, General Data Protection Regulation, to DSA, Digital Services Act, and many other pieces of legislations. We count among about 120 digital regulations. Some speak about the legislative spaghetti or a normative inflation, because there are many, many legislations. Because there are so many legislations, EU is starting to be a bit concerned about the amount of work and legislations to be able to navigate, how startups will be able to navigate between all of them. And therefore, there is now an ongoing process of potentially deregulate or at least simplify these digital regulations, which is the so-called digital omnibus. Happy if you want to speak about that later. But for now, I just get back to the EU AI Act, this regulation that deals with AI. As mentioned, is a safety regulation, safety because it's similar to a product safety regulation, such as medical device regulation, because you need to comply with many detailed regulations and requirements so as to be able to put an AI model or an AI product into the EU market. And therefore, some of them compare the EU AI Act with the so-called product safety regulation similar to the medical devices. The EU AI Act focuses on the so-called AI system, which is not all kind of AI models, but it's the so-called AI systems defined as a machine-based system with a level of autonomy that infers from input, training data, how to generate output. While other technical and experts in the past were talking about AI like a machine that imitates human intelligence. So just to say that while the technical experts have a very wide definition of a broad definition of machine imitating human intelligence, the AI Act defines AI system as machine-based system with autonomy inferring from input how to generate output. So having said that, indeed, interpreters, vendors, agencies, providers, many of them uses more and more AI in their workflows, from KAI to AIST models. At different parts of the workflows, there will be AI models that will comply with the AI system definition of the EU AI Act. On the top of that, the EU AI Act has a extra geographical scope, which means that it applies no matter where the company is based, to the extent that they provide services within the EU or EU individuals. And therefore, very quickly, many providers within the EU or outside of the EU, and you mentioned KAI, if you do from a cloud-based service and tools, you probably will be part of under the EU AI Act due to the extraterritorial scope. Now, let's dig into the details of the EU AI Act. It follows a so-called risk-based approach, which means the higher the risk, the stricter the obligations are, and it categorizes, it defines 4 different levels of risk. One is a so-called unacceptable risk. In other words, there is a ban, a prohibition of such AI models, which relates to everything in terms of social scoring system, i.e. system that ranks people based on their social behavior to assess some services depending on the behavior. Social scoring is banned. Another banned AI models are those doing facial recognition in real time in public spaces, which leads to mass surveillance. So these 2 examples, social scoring and facial recognition in public spaces, are in general prohibited. Then we enter into permitted AI models, but with different sets of obligations, particularly the so-called high-risk AI models, high-risk AI systems that have heavy obligations like periodic review, updating, transparency, and so on. And this relates to some sectors in which the AI models will be used and deployed. For instance, for medical devices, for justice, for HR, human resources, if you sort out the job applications based on the AI model. In education, if you deploy AI models within schools, or assessment of credit worthiness of individuals, if you want to know the credit worthiness for an insurance policy or bank loans. And finally, for biometric data or emotion recognition, all these sectors are deemed to be high risk, and therefore they come with a heavy set of obligations. So if an interpreter or his or her agency is doing interpretation for these kind of sectors, medical, justice, court, HR, education, and so on, this will be deemed to be high risk with these heavy sets of obligations. I will come back to that. Just to mention, the third type of risk is the so-called limited risk, which is, by the way, probably 80% of the sectors and of the users. Limited risk that most AI systems, from chatbots to interpreters working in non-dedicated sensitive sectors, in all these sectors and chatbots and other models, limited risk, there is mainly an obligation of transparency. And finally, a fourth last category of risk is a so-called low risk or minimal risk, which relates to spam filters or just basic AI models that are integrated into our laptops and or smartphones. These are so not regulated, meaning that there is no additional requirements under the EU AI Act. Having said that, unless you have follow-up questions, maybe I try to decline to apply these risks into the interpreting value chain.
Yes, if you could please maybe apply this on the work of interpreters. We can differentiate maybe different scenarios. On one hand, we can, for example, have a conference interpreter servicing a standard conference, I don't know, at the political level. And on the other hand, because some of the things that you mentioned related to healthcare, for example, or processing of personal data or recognition of emotions. So we can, for example, visualize police interrogations or interpreting in the field in medical settings. So how would this impact the use of ASTs at these various types of meetings?
Sure. Thanks. So let's just recall that under the EU AI Act, there are mainly two types of actors that are under strict requirements. On the one hand, we have providers, i.e. those developers who develop an AI model and put that model on the market. They have the most obligations. And on the other hand, we have mainly the deployers, which are basically the users using an AI model, or organizations or individuals, an agency or an interpreters that use an AI system in their professional activities. And they have also obligations, but fewer obligations, mainly if it's high risk, they need to ensure transparency and human oversight. So let's try to apply these two types of deployers and providers with the interpreting value chain. So if we have, for instance, an automated speech translation model, AST, or a KAI tool that is provided by a company, let's say, for instance, DeepL, that provides some translation tool, or DeepL Voice, excuse me, this DeepL Voice will be deemed to be a provider, and they have the most obligations. Then when the interpreter is using, either directly or via his or her agency, then they use this KAI or this AIST platform, for instance, DeepL, to help them to translate. They will be deemed to be deployer because they are user, organization, agency, or individual interpreters that use this AI model within their professional activities. And they have few obligations, particularly if it's a high risk. They need to ensure transparency and human oversight. Transparency means that they need to indicate to the persons which is translated or interpreted, the clients, they need to inform them that they are using synthetic or generated works. In other words, that every word that comes from their mouth will be generated by an AI model. That's what we call the machine notice. And then they also have a requirement of human oversight, which means that they must always be able to recheck the synthetic and generated output. And if there are too many bias or wrong outputs, they need to put the stop button and try to replace the AI model. Just a last word to mention that on the top of providers and deployers, for instance, DeepL as provider and interpreters as deployers, we also have general purposes AI model. For instance, ChatGPT, and they all have also a specific set of obligations under the EU AI Act on the top of providers and deployers, particularly detailed transparency requirements. So for instance, if DeepL or Zoom, Microsoft Teams, Google Meet, any other tools are using LLM like GPT or any other LLM, this will be a so-called general purposes AI, GPAI, under the EU AI Act, which have also an additional transparency requirements to comply with.
All right, so let me ask a follow-up question. EU AI Act introduces a tiered risk-based approach, but at what point AI interpretation reaches the category of high risk? You already mentioned some contexts, for example, police work, medical settings, I can imagine court or asylum interviews, but I was wondering about a slightly gray area more situations, such as, for example, a large organization is deliberating an important issue at the high level, and although the speeches are highly cliched, it might be tempted to use AI, and people will get at a very high level possibly the wrong idea, or the organization itself will suffer reputational damage. Would you say that in situations like this, AST could be considered a high-risk AI application or not? What is your opinion?
Right. No, I think for sure. I mean, we are navigating into new law. We haven't mentioned yet that the EU AI Act has not been fully entered into force. And with the digital omnibus, there will be also delay, particularly for high-risk systems. So it's not sure yet when exactly the high-risk requirements of the EU AI Act will enter into force. And we navigate into new areas, such as drawing the exact line between high risk versus low risk. Having said that, I think in the interpreting world and services, as soon as the underlying people who are translated, as soon as these underlying people are working in these sensitive, high-risk sectors, justice, medicine, human resources, and so on, they will be deemed to evolve into a high-risk sector, therefore triggering the high-risk requirements. So I would be, at least if you want to have the cautious approach, is to assume that all the underlying translated people working in these sectors of the annex of the EU AI Act that lists all the high-risk sectors, then it should trigger the high-risk requirements.
That's very helpful.
As opposed to that, all the other sectors that are not in the Annex 3, that lists the high-risk sectors, I think an interpreter or his or her agency could assume that it's a so-called limited risk area, therefore no strict requirement, just the transparency obligations, i.e. make clear to users that they are interacting with a machine, what we call the machine interaction notice.
Thank you. And a second follow-up, if I may. In a situation where human supervision is required, and I think you made it clear that there always should be a human in the loop, always supervising the output of the machine. In case of real-time simultaneous interpretation, how could that be possibly achieved? Is that a feasible goal, or is it something that you could talk about?
That's what I said before. We are navigating difficult eras, and again, this human oversight required for high risk is not entered into force yet, and with the digital omnibus there will be delay. So we are navigating into new eras. Having said that, I think, but that's my own personal interpretation, I think human oversight needs basically to have a clear stop handover to human mechanism that ensure immediate fallback to qualified human interpreters if the output becomes unreliable. So I think basically there shall be, so to say, just such a stop handover button to humans, so that the interpreters can take the to replace the artificial interpreters in case the output is unreliable. But that's again my interpretation, and probably when it will be fully entered into force in a few years, it will be clearer to what extent human oversight needs more than just a fallback button.
Yes, indeed. And the technology is evolving so fast that it's very difficult to determine where we will have it in a few years. And obviously, regulation is always only catching up with the most advanced models on the market. But you've mentioned a situation where an interpreter or a human supervisor may be supervising the work of an AI-powered tool. How about a reverse scenario? How can we, what about a situation where, for example, AI tools would be used in a performance management of interpreters or in employment of interpreters? So what about this situation? Is there anything that the EU AI Act says about these cases?
Can you repeat the scenario?
So a reverse scenario when an AI tool is used for performance management of interpreters, for example.
But can you give a concrete example of performance management of interpreters?
For example, the AI tool will be employed in order to monitor the output of interpreters, to assess it, grade it, give it some marks that will be then used by human resources or by the agency or the employer of the interpreter to assess the performance of interpreter.
Right. In my view, that's the future of the coexistence and collaboration human machines, and that's why I'm trying to be optimistic in terms of collaboration coexistence. Instead of thinking of replacement, I think of displacement, or AI models as assisting tools, and I think this could be a good example of AI being a very useful assistant and assisting tools for interpreters and to improve themselves. That's my opinion. I'm sure it's a delicate question, but having said that, beyond the economic part or the change in intellectual professions, interpreting professions, let's just mention again the legal aspects. If interpreters are monitored by an AI model, this will monitor some personal information and personal data, if not copyrighted data, if the interpreter has copyright on his or her interpretation. But beyond copyright, I would get back to the privacy and personal information. Everything what is an information relating to an individual, such as an interpreter, will be a personal data, a personal information, which triggers not the EU AI Act now, but the GDPR, the General Data Protection Regulation, that has another set of regulations and requirements in terms of privacy and data protection. Some of them, or most of them, will be the consent of the interpreters to use this tool or to be used by this tool. Beyond that, there will be minimization principle, i.e. the model shall ensure to harvest and use only the minimum data required to achieve the purposes sought. And also there will be security, data security. The AI model needs to ensure that the data will be secured and not out there and subject to data breaches. I can talk hours about GDPR and personal data protection. I don't know if you want me to comment more on that, but I think it's an interesting example that you brought with the AI interpreting the interpreters.
We do want to ask one follow-up on that because it's so important. How should interpreters understand and protect their rights when their voice and output is used by to train AI systems? We understand that it will have to be consensual and it is protected by the GDPR. But let's say in a real situation where interpreter is there to serve, how would interpreter behave and which particular law, which particular item he or she should quote to make sure that this information gets through and their rights, interpreters' rights, are protected?
So with this question, there are many different scenarios, right? It can be either the interpreter using AI-powered tool that harvest personal information of the people interpreted, and in this case, there will be GDPR or other privacy laws applicable that protect the persons interpreted, and therefore the interpreter or the agency working for needs to inform the people translated that their data are harvested or used to be trained, to train AI models. Now, the inverse scenario mentioned by Pavol, if an agency is harvesting the interpreter's data, this will come to the protection of the interpreter's personal information, and the interpreter needs to give his or her prior consent. So there are different scenarios. It can be the personal information of the interpreters or the personal information of the clients that are translated. And in these two cases, usually you need to have the prior consent, either of the interpreter or of the client. For interpreter, for the consent, I would say that the consent is rather implied because the interpreter proactively accepts to use this kind of AI-powered tool to be corrected or monitored. So we could probably assume either under the GDPR or other privacy laws that there is an implied consent by accepting to use the AI-powered tool, as opposed to the client. If the client has no idea at all that his or her voice is harvested and used to be trained, to train an AI model, then you will need either the agency or the interpreter directly needs to inform the client and obtain his or her prior consent.
That also be the case in applications of CAI, computer-assisted interpretation tools, which basically act much the same way as AST. There is even a bit of an overlap, and client's information is definitely captured. Their personal output, their presentations, their thoughts, it goes through a black box. And sometimes we differentiate AI into three categories: as replacing interpreters, as using interpreters, which you have just described, and this category is helping interpreters. In other words, we're talking about benign AI that helps make super interpreters out of human interpreters. So what are our obligations in this case? And sometimes, I just need to mention, interpreters act as agencies and providers of services, and sometimes they're just providers of services to an institution or an agency.
Right, so the prior consent of the clients is lies on the so-called data controller, which will be the entity deciding to use or not the CAI tool. So if it's the agency, this will be the data controller that shall ensure the prior consent. If it is, however, the what did you say again? What the example of not the agency, but the
when the interpreter is an agency as well as a provider of services.
So if the interpreter directly contracts with clients to be interpreted, this is the data controller to ensure to have the prior consent. Then the prior consent needs to be very detailed, right? So the interpreter or the agency needs to inform in detail what about their data. First, that KAI tools will be used, but also potentially where and how long will the data will be stored and sent. And in most cases, KAI tools, because it's based on cloud, are sending personal information worldwide, either in the EU, in data centers in the EU, but also in the US, Philippines, and so on. And this shall be mentioned to the client so that they are aware of that.
If I may now take a slightly broader perspective, and I know we don't have crystal ball, and it's almost impossible to make any long-term predictions, especially in terms of AI evolution. But we have seen some pressure exercised on the European Union, especially from the United States, but also from other parts of the world regarding the existing legal framework, especially when it comes to regulating large multinational entities that operate general AI models. Do you foresee any, or can we already talk about some changes envisaged in the legal structure or the legal framework that we have just analyzed? And what is your maybe prophecy or vision for the future in terms of how the rules may change and adapt regarding these political pressures?
Right. So without, as you said, having a crystal ball, I would say everyone is on the race of AI, of course. From Asia to US to Europe, everyone is on the race. So everyone is also on the race of the good, clear regulatory framework. And it's always difficult to find the right dosage, the right balance between, on the one hand, protection, and on the other hand, innovation. And therefore, be it US, Europe, or Asia, everyone is trying to find this right dosage and right balance, innovation versus protection. And everyone is on the race of this good regulatory framework. Having said that, we saw the previous years that Europe specifically wanted to be a global leader in trustworthy AI with a strong regulatory framework, but somehow recently they realized that their legal framework is potentially too detailed, too complicated for startups and other small companies to be in the race, and they potentially want to simplify these digital regulations starting from the EU AI Act. One of the simplification could be for high-risk systems. They are trying to postpone these high-risk requirements, potentially to reduce some transparency and or documentation and audit requirements. And also for GPAI, general purposes AI, they try also to see if they should simplify the package and the sets of requirements. I don't know if I replied to your question, but just to say that because everyone is on the AI race, but also on the regulatory race, EU is indeed putting some step back in terms of detailed regulation. And you said no crystal ball, but I don't know if your question was how will the legal landscape looks like in 10 years. I would say, but that's only wishful thinking. I would say hopefully some international principles that are applicable worldwide, starting from non-discrimination, no bias, and so on, human rights. And on the other hand, every jurisdiction should have at least some legal framework that protect the minimum like transparency and discrimination.
Pavol just took you to a higher level, and now I am going to narrow down again. Emerging national landscape. There are now national regulations, in particular Italy's new AI law, which are early examples of national regulation under the EU framework. What can you say about these first exercises in national legal AI autonomy.
Perhaps I may jump into it because you mentioned before the recording that you are also involved in drafting the Swiss legislation in this respect. So we really have an expert on this area here.
Right. So indeed, because every country is in the race of regulation, also the right dosage, innovation versus protection. There are now also countries, even member states from the EU, starting with their own national legislation on AI, starting with the Italian AI law that you mentioned, which is interesting because it's of course aligned with the EU AI Act. It has to, because it's a EU law plus a regulation, not a directive, a regulation. So it has to be aligned. And it's also interesting because it has some details and specificities for Italian law. I'm not an expert in Italian law, but let me just mention interesting specificities. It regulates areas like professional roles, sector-specific safeguards, and particularly, it provides that AI must support, not replace human professional, which, by the way, requires to distinguish between AI supporting versus AI effectively replacing, not an easy task to distinguish. It also requires a human oversight, and remember that's also a requirement for high-risk systems under the EU AI Act. So Italian law requires a human oversight whenever AI tools are used, and it also requires that AI tools must be disclosed, in other words, inform clients in advance that AI tools are used. So these kind of requirements, these three requirements echo, of course, the EU AI Act. Maybe the most interesting one is the requirements that AI must support, not replace human professionals, with the difficulty in distinguish between AI supporting versus AI replacing. Nevertheless, it places the human being at the center of the intellectual professions, or just in general, human professionals. And this seems very interesting. Then a question of enforcement and drawing the line. This will be, without crystal ball, probably a difficult task.
That's what we gather as well. And our Italian colleagues, of course, would have liked to see a little more specificity, because something that the new Italian law can be a little vague in some spots, especially in this one about supporting professional activity. We're not going to go into that. I know that you could give us another hour, you can, please go ahead.
No, I just wanted to get back to the example of Pavol. Maybe we can try to imagine two scenarios: an interpreter using AI to support his or her work, or inversely, interpreters whose work is interpreted by an agentic model or an AI-powered tool. In these two cases, there will be the question, can the interpreters be fully automatic interpreted, or a client can be fully automatic interpreted? I guess the Italian AI law does not ban automatic translation in general, but requires at least a qualified human interpreters that comes into place to verify, correct, check, and we get back to this human oversight in case of synthetic generated output that are unreliable. But that would be my interpretation. And again, as non-Italian lawyer, I would be happy to have a discussion with our colleagues from Italy.
They would love that, I'm sure. So, Yaniv, we have taken plenty of your time, and at this point we probably need to conclude. And I just want to mention that we love you not just for your expertise, but also for the fact that you are an optimist, and you always bring us the most thorough and the most optimistic interpretation of the law. I also want to add that no part of this interview constitutes legal advice. For that, you will need to hire Yaniv privately. And on that note, I would like to thank Yaniv Benhamou. I would like to thank Pavol, Šveda, and Laura Halcom. I hope to meet again very soon.
Thanks for listening. Stay tuned for more exciting insights and updates on everything AI.